Hello and welcome to this New Zealand Initiative webinar, Who Makes the Law? Reining in the Supreme Court. We're here to launch our new report, same title, written by Roger Partridge, and we're privileged to have both Roger and Jack Hodder with us on the webinar, and I should introduce both of you. Roger is the author of this report we're launching today. He was previously a litigation partner at law firm Belgali for 24 years. And for nearly a decade of that period, he was also the executive director of the Legal Research Foundation, a charitable legal think tank associated with the Faculty of Law at the University of Auckland and publisher of the New Zealand Law Review. Roger is also one of the Foundation's honorary fellows. He's a former member of the Council of the New Zealand Law Society, the governing body of the legal profession. He left Belgali in 2015, and he's a senior fellow here at the Initiative, where he spends his time researching regulatory and legal policies most of the time. And we're privileged to have Jack Hodder with us, a barrister and senior King's Counsel. He's one of New Zealand's most respected litigators with over 40 years of experience, appointed King's Counsel in 2008. Jack has appeared in more than 600 cases in New Zealand's superior courts. He specializes in commercial, regulatory, and public law matters. He was formerly a partner at Chapman Tripp and now practices as a barrister at Thornton Chambers in Wellington and Shortland Chambers in Auckland. And I should also mention that Jack is the author of an excellent paper on the Supreme Court published earlier this year, which really triggered a lot of this discussion, which then eventually led to Roger's report we're launching today. I should tell you a little bit about the proceedings today. For those of you who've been on webinars with us before, you know how it works. We will hear from Roger first, who will introduce his report. We'll then hear Jack's comments on Roger's report, and then we'll have probably around 40 minutes for Q&A. And you can all participate in the Q&A. It's simple. All you have to do is you go on slido.com, and on Slido you enter the code 4021803. And I've just put the code in the webinar chat so you can all find it. The good thing about Slido is you can ask any question you like, but you can also ask you can actually vote on other people's questions. They will all come up, and I'll promise I will ask the most popular questions. But for now, it's time to launch the report, Who Makes the Law? It's a critical stocktake on where we are in New Zealand with our Supreme Court and whether reforms of our top court are necessary. But to introduce the topic of his report, I'll invite Roger to summarize it now.
Thank you, Oliver. And thanks everyone for joining us to examine the growing power struggle between Parliament and the courts. It's an issue that strikes at the heart of our democracy and the rule of law. And for non-lawyers, what I mean by the rule of law are the features of the law that involve the courts deciding cases impartially and judges deciding cases in a consistent and predictable way, both key features of the rule of law. The problems that we see in this struggle for power between Parliament and the courts stem from a series of increasingly misguided decisions by New Zealand's highest court, the Supreme Court, which has seen the court blurring the line between judges' traditional role of interpreting and applying the law in the context of particular disputes between litigants and Parliament's job of making the law. We only need to look at the cautionary tale from the United States to see what can happen when judges become lawmakers and effectively politicize the judicial role. An activist approach from the US Supreme Court has led to less certain and predictable law, less trust in the impartiality of the judiciary, and an erosion of the democratic legitimacy of the US legal system. Our Supreme Court, the report contends, seems blind to these risks and intent on taking the legal system here down the same dangerous path. Of course, concerns about judicial overreach or judicial activism aren't new, and they predate the Supreme Court's formation. But the court's recent jurisprudence, or its legal method, suggests we may be reaching a tipping point. The report targets some of the underlying problems and proposes solutions for Parliament. Before elaborating on my views, I want to provide a bit of context for them. I've spent the last few years writing on public policy and economics at the Initiative. I was drawn back to legal writing by a succession of Supreme Court decisions. The first was the court's wildly misguided Make It 16 decision concerning the voting age and whether 16-year-olds should have a vote. the majority decision of the Court of Appeal, in its misplaced enthusiasm to intervene in a patently political matter, led it to overlooking the critical legal issue, which sadly was only obvious to Justice Koch in his dissent. I wrote a column on the decision in Newsroom and shared it with former Otago law professor Jim Allen, now Professor of Constitutional Law at the University of Queensland. Jim then wrote about the decision in his guest contribution to the 60th anniversary edition of the New Zealand University's Law Review, and in a subsequent newspaper column, Jim described the decision as an example, and I'll quote from him here, an example of an emerging imperial judiciary in New Zealand where the top judges are giving themselves new found power at the expense of the elected branches of government. Under the cover of purportedly applying the law, they are usurping power to themselves. And Jim's words succinctly capture the essence of the issues my report grapples with. The court's more recent climate change case earlier this year was another which I wrote about in the New Zealand Herald this time. And there was an appeal from the Court of Appeal. The Court of Appeal had struck the claim out. And in doing so, it ruled that climate change, and again I'm quoting from the court, could not be appropriately or adequately addressed by common law claims pursued through the courts. It was quintessentially a matter, the court said, that calls for a sophisticated regulatory response at a national level supported by international coordination. The case went to the Supreme Court. The Supreme Court felt no such constraint. It reinstated the claims, and by permitting them to proceed to trial, it's inserted the courts once again into a politically charged role, which many think is more suited to Parliament. The report deals with several other Supreme Court cases, and I'll circle back to some of these in a moment. But I can't do justice to the context of my concerns and recommendations without a reference to Jack's wonderful paper critiquing the Supreme Court's legal method. Jack, no doubt, is known to many of you, and I'm delighted we're hearing from him today. His paper was delivered earlier in the year at the Legal Research Foundation's conference to mark the Supreme Court's 20th anniversary. I wrote up aspects of Jack's column in a critique in a Herald column in March, and I wrote a follow-up column a couple of weeks later with some thoughts on how Parliament should respond to the concerns Jack had raised. This then led to the larger project and resulted in the report we're launching today. The issues raised in Who Makes the Law, and before that by Jack, centre on two key areas where the Supreme Court is overreaching. First, the courts adopted a troublingly loose approach to interpreting and applying laws passed by Parliament. The court's now stretching or even sometimes ignoring clear wording to reach outcomes it prefers. Effectively, the court's granted itself license to rewrite legislation it does not like, overstepping Parliament's rightful role. And as an illustration of that, I have a detailed analysis in the report of the three strikes case of Fitzgerald against the Crown in 2021. It's a prime example of the problem I describe, and that problem is helpfully illustrated by the strong dissenting judgment from Justice Willie Young. The second area where the Supreme Court's overreaching is in its approach to the common law. Common law is the body of rules judges have made through court rulings over centuries. The feature of the development of the common law is incremental, filling in the gaps. But our Supreme Court now favours a radical new approach of reshaping common law rules to match the current judges that make up the court's views of society's changing values. Now, that approach represents a significant departure from the traditional common law method, and it doesn't take much thought to work out what's wrong with it. The judges aren't equipped or accountable for making these types of broad policy decisions. How do they work out what society's changing values are without the sort of inquisitive or inquiry process and submission-making process that our democratically elected Parliament is able to undertake? Because of these problems, another senior judge from the UK, Lord Bingham, wisely cautioned in his seminal lecture as a guest at another Legal Research Foundation conference in Auckland that judges should exercise particular restraint in developing the common law in areas where the issues involve current social policy on which there's no consensus in the community, or where the issue is currently being addressed by Parliament. These constraints are ones which our Supreme Court doesn't even pay lip service to any longer. And the Peter Ellis case starkly illustrates the court's radical approach and its pitfalls. And again, there's a detailed study of why that's so in the report. The shift from filling in the gaps, if you like, and interpreting and applying laws, faithfully interpreting and applying laws passed by Parliament, to one where the courts play a lawmaking role, the flaws with that are easy to understand. We end up with unelected, unaccountable judges making big social policy decisions, which is really under our constitution the role for Parliament. And by blurring the lines between judging and lawmaking, the court is really stepping into Parliament's roles. That shift weakens the democratic standing of our laws. It makes them less consistent and predictable, and that strikes at the heart of the rule of law. The report proposes 5 tools for Parliament to restore the balance to our legal system. And that's the second half of the report. The first is targeted legislation. That's obviously Parliament's most blunt response to judges overstepping their bounds. In the legal hierarchy, Parliament is supreme, and it can pass statutes to ensure the courts give effect to its wishes. The Labour government did this in 2021 in response to the Supreme Court's decision in D against the police, and the current coalition government is proposing to do the same in relation to the court's response to the Marine and Coastal Areas Act. Parliament, I submit in the report, I argue in the report, should not hesitate to correct other court decisions that go too far, and it should overturn the worst of them. This would send a clear message to the courts about the limits of their role and the need for them to stay in their lane. Parliament's second option is to pass legislation defining what it means by the rule of law. That would introduce clearly defined guardrails, if you like, in the Senior Courts Act to help keep the courts in their lane. Helpfully, the Senior Courts Act refers to New Zealand's continuing commitment to both the rule of law and the sovereignty of Parliament. There's no doubt about the meaning of the sovereignty of Parliament, but nowhere in the Act is the term rule of law defined. And while it has an orthodox, narrow meaning, unless it's defined, it's susceptible to manipulation, and I explain why in detail in the report. Parliament defining what it means by the rule of law would help moderate the Supreme Court's interventionist tendencies. Parliament's third option is to tighten its instructions to the courts about how they should go about interpreting statutes. The existing instructions are in the Legislation Act 2019. Section 10 of that Act, as every lawyer will know, directs the courts that the meaning of legislation must be ascertained from its text and in the light of its purpose and its context. The report recommends amending Section 10 to make it clear that when considering the context of a statute, the courts should only look at the context at the time the legislation was enacted. And that would prevent the courts doing something they're inclined to do, which is to take what's sometimes called the ambulatory approach to statutory interpretation, where the meaning of laws is claimed to change over time with the court's assessment of changing societal attitudes or values. But that's obviously not what Parliament means when it passes laws. The report also recommends expressly limiting the principle of legality. That's a presumption the courts now use to prevent what they consider to be fundamental rights being overridden by general words. But it's being used to trump, rather than as a way of resolving ambiguities, it's now being used as a trump card to overrule the words used by Parliament. And the report recommends that a new subclause is added to Section 10 to make it clear that the courts can't use presumptions to displace clear statutory wording or adopt unreasonable interpretations of Parliament's words. Parliament's fourth option is to reform the way the Bill of Rights Act affects other legislation. In particular, Parliament could consider amending or even repealing the troublesome Section 6 of the New Zealand Bill of Rights Act 1990. Section 6 requires the courts to prefer rights-consistent interpretations of statutes where possible. Until its decision in Fitzgerald, that's the three strikes case, the Supreme Court had considered it could only adopt meanings of Parliament's words that were reasonably open or available, but in Fitzgerald, that restraint was rejected by the majority of the judges. Ironically, it follows that the court, or at least the majority of the court, is happy enough to adopt unreasonable meanings of Parliament's words, and we can all see the problems with that. Parliament should push back against this and either repeal Section 6 entirely or at least clarify that courts can't use it to adopt meanings inconsistent with statutory intent or to adopt unreasonable interpretations. And fifth and finally, the report recommends two important changes to the judicial appointment process. First, new criteria should favour candidates for appointment to the appellate courts who have demonstrated judicial restraint and respect for the sovereignty of Parliament. And secondly, Parliament should consider fixed terms for Supreme Court judges. This could help prevent our most senior judges from becoming too detached from the practical realities and guard against them gaining an exaggerated view of their role. Stepping back, these five options give Parliament several complementary ways of tackling judicial overreach. None of them threaten judicial independence or the rule of law. Instead, they'll protect these fundamental values by making sure the courts stay within their proper bounds. And that's my summary. Thank you, Oliver.
Thank you, Roger, and congratulations on the report. It's a very good piece of work. And I should mention, of course, you can all read it now. It's on the front page of our website at nzinitiative.org.nz. I would also like to remind you that you can submit your questions to Roger and indeed to Jack Hodder via Slido. Once again, the code on slido.com is 4021803. But now I look forward to hearing Jack Hodder's thoughts on Roger's report. Over to you, Jack.
Thank you, Oliver and Roger. Just so nobody's in any doubt, I am here to praise Roger's paper, which should become famous as the Partridge paper on judicial enthusiasms. But it's an awkward topic, talking about courts and judges. Most people don't know a great deal about them. It's a rather mystical world, and most of those who write about it in accessible form tend to be the judges themselves or academic lawyers who have an enthusiasm for novelties. That sometimes seems like a feedback loop between the judges and the academics, which doesn't help the process in the opinion of at least some of us. But so Roger's paper is a good paper, a very good paper, and it's assisted because he has the credibility from being, as Oliver said, a very experienced, very well-regarded senior litigation partner and a leading New Zealand law firm for a long time, in addition to his other experiences. So it's a careful and valuable report. The part that was most interest to me was the Chapter 3 discussion of responses. How should Parliament and the Executive respond? That's the constructive part of the report that says, here are things that we might do, given that there is a problem that had been identified by some of us. And that's the part that I hope gets particular attention in the discussion, which is no doubt going to go on for some particular time. I should say of my own paper that it wasn't ever intended to be an exposition of judicial activism, as the phrase has it. I was simply asked to write something about the first 20 years of the Supreme Court from a litigator's perspective, and I've been appearing in the court since pretty much when it started in various cases. And I should also say that that paper was written before the last election, but after the US Supreme Court in Dobbs reversed the position that arose in relation to abortion in the US. What was interesting about the paper is that, no doubt those who didn't agree didn't say anything to me, but those who did agree came up to me and said, it's a good paper, but you were very brave for writing it, which is a bit of a worry because it seems to me that this topic confirm that this topic is one on which a number of lawyers are possibly a little afraid to put their head above the parapet because they think somehow or other that may be problematic. I don't think it should be, and I think the judges themselves, who are sound, for the most part, sound personalities, don't hold that against anybody, and the debate should take place. And I've no doubt it will. But the underlying issue that we're both talking about is, what is a democratic society about? And the obvious proposition that underpins Roger's paper, and indeed my own, is that lawmakers are expected to have a democratic mandate, and they're expected to be democratically accountable. If you think about judges, they aren't. That's the core of the issue. And what lawmakers do when they're legislators, is they speak through the language of statutes. So what judges do with the language of statutes matters. And one of the things that one doesn't really want to have is the idea that what legislators write is simply a first draft of what the law means, and then the kind of gets improved into a second and further draft by court analysis. That isn't the way it's supposed to work. That isn't the way it has worked in the past, and it isn't the way it should work in the future. But at the moment, there's a real risk that that's the direction of travel, not just in New Zealand, I should say, but also in some other courts around the English-speaking world. So as I say, judges are different, but they're important because of the influence they have on the legal system and on the way in which rules are applied to people. So what's our key expectation of judges? In my view, it is that they are impartial. That's why the oath that judges take talks about without fear or favour. That means, among other things, that they should be applying established law. It means that they don't have an agenda, and it means it shouldn't make any difference who the judge is. Unfortunately, as we can see by the benefit of the kind of US experiment in this, it does make a difference who the judges are on political matters. That's what's happened in the US, most spectacularly in relation to the abortion debate. If you change the judges, you change the law. That's not the way we have ever done things, and it's a particularly unattractive way for some of us to think about it happening in the future. And so at the moment, we have the advantage that almost nobody knows who our judges are. There's no process of any public nature when they're appointed. It's an almost anonymous process. I think that's fantastic. But if you start making major political decisions through the courts, then that's going to have to change. Some element of democratic accountability, either beforehand or after, is going to have to take place. And that's really the issue that we are looking at. And ideally, we would head off by encouraging an avoidance of finishing up in something analogous to where the US courts are. It's probably important to say, and I don't know that Roger touches on this in his paper, that parliamentarians share a decent chunk of the blame. It's no good just saying this is a problem from the courts, it's a problem from parliamentarians. There are many pieces of legislation which don't help this process. My personal hobby horse is the New Zealand Bill of Rights Act. It was misconceived from the outset, and it's a pity it wasn't sort of strangled before it got onto the statute book. It was only half strangled, but it was causing enough trouble. It's important to say that rights are claims as far as the legal world is concerned. So rights don't trump everything else. Rights have to jostle with each other, and whoever gets to label something a right gets a rhetorical advantage, but it doesn't mean it's any different or better than somebody else's claim or right. But what Section 5 of the Bill of Rights Act does is it says that the courts get to decide whether a right being constrained in some way by legislation is justified in a free and democratic society. That means that the courts are immediately elevated into passing a judgment on the substance of the legislation. It just sets things going down the wrong track entirely and makes people think they're a constitutional court when our courts are not constitutional courts. Roger has mentioned 6 and 6 about consistent interpretation, where the interpretation that's rights compliant is to be preferred to any other meaning. Any other meaning you would think means any other reasonable meaning, but the case he indicated, there's a suggestion that we are now in a direction of travel that says any meaning means any meaning. And then there's the treaty principles. The treaty principles are an interesting concept. The treaty is hard work. Treaty principles are harder work still because they kind of came into existence as a notion quite quickly and then became catapulted into prominence in Section 9 of the State-Owned Enterprises Act in 1986, which led to the Court of Appeal having to work out what it all meant. The classic point where there wasn't much scope for the court to duck the issue, the court had to do something, and so it did, and it came up with this something akin to partnership idea, which we're still wrestling with 40 years on. All of that does mean that Parliament needs to be very cautious about what it enacts and conscious of the fact that if it doesn't make itself clear, then somebody else may finish up doing the second draft of the act, as it were, and making it something that wasn't expected. And ideally, we wouldn't have that because the legislation was clear in the first place. As to what should be done, I endorse almost all of what Roger says. I think that all those points are sound, although I have some reservations about screening of judicial appointments. That kind of cuts in all sorts of directions. And I haven't ever seen something that completely satisfies me that any other jurisdictions got that right either. So at the moment we have an informal process, which as a matter of pragmatism has worked quite well. But the moment you start saying we're going to have a screening process, then there's a real contest as to who does the screening. And so you always get one stage of decision further back and trying to sort it out. It's important, I think, to say that there are outstanding issues in relation to the Supreme Court's operations. I was on an advisory group that advised Margaret Wilson when she was Minister of Justice, chaired by now Sir Terence Arnold, in relation to what a replacement for the Privy Council, which is what the Supreme Court was and is intended to be, how it should operate. The expectation was it would do maybe 40 or 50 judgments a year. It's currently doing something in the 20s. That means it's doing a low number of cases with a lot of time to do them. Conversely, the Court of Appeal is seriously overworked and doing hundreds of cases every year, although it's a larger court and sits in panels. It doesn't require rocket science to figure out that if you equalized the workload, you'd finish up with a wider number of judges at the higher appellate level. And you could, for example, come up with the idea that maybe you just have one overall appellate division. And when you've got a second appeal, you draw by rotation just 7 of them. And they are deciding it, but it's not a permanent court. And if you do that, then you avoid also the issues about whether one or more appointments makes a critical difference, which, as we know from the US example, can happen. So I haven't got to a view about that yet, but it's a sort of issue that is going to have to be debated, because it seems to me that we can't be completely comfortable that our appellate system is in the right shape and right structure. There are many other things that need to be discussed, but I think they probably better come out of a question and answer exercise, which we're about to embark on. So if I go back to where I started from, it's an excellent paper by Roger that deserves wide attention and absorption, not least by legislators and would-be legislators and by public policy enthusiasts everywhere. Thank you.
Well, thank you very much, Jack. And as you said, we are now moving towards the Q&A part. Reminder again, you can ask your questions. They're rolling in on Slido 4021-803. And the most popular question right now actually builds on something you just said, Jack. So I might ask the question to Roger. Is the Supreme Court filling a vacuum left by ineffective parliamentary leadership?
I think the question's getting at whether Parliament sometimes doesn't fill the blanks or isn't clear enough about what it means. And I think that is part of the problem. This report is also a wake-up call to Parliament not to kick the can to the courts, because it will encourage a practice of the courts thinking it's their job to decide what the law should be. And that's categorically not our system of government. Our system of government is that it's the primary job of Parliament to determine what the law is and to be accountable to voters for that. And it's proved a remarkably robust system of constitutional government, and one we should be very careful about allowing to decay.
Another way one could read the question is actually whether it is Parliament's role to intervene when it sees that the Supreme Court goes in a different direction, Jack.
But all the issues that have been raised and propositions raised by Roger's paper go in that direction, that it requires Parliament to consider these matters carefully and not to ignore them. And that means everybody in Parliament, not just the current government or a future government, because all governments' programs are subject to these same issues. It's something which you would almost hope, that may be over-optimistic, you'd hope there could be something that's more than simply a one side of the House view about.
Okay.
Well, if I can just add, if the question is getting at whether it's part of the problem is Parliament's failure to intervene when the court goes off the rails, I think Parliament generally has been a bit hesitant about that, but it unquestionably shouldn't be. It's unquestionably within Parliament's prerogative to set the course of the law in any particular field. And if it thinks the courts have taken it off in the wrong direction, it's Parliament's job to intervene. And Parliament will then be accountable to voters for having done so. But that is our system. And the court intervention by Parliament to reverse wayward court decisions in the past has been rare. But as I say in the report, that's because mistakes by the courts are usually inadvertent and not deliberate. But a court that's consciously radical, like our current Supreme Court is, can expect to be overturned and should be overturned more commonly by Parliament.
Okay, we've got a very punchy question here. Is it the values of the judiciary leading them to be interventionist, or is it a contempt for parliamentary sovereignty and democracy? So which one is it? Roger.
Well, that might be a false dichotomy. I think the courts are not sufficiently deferential to Parliament. So definitely it's partly the second part, the alternative. As to the political philosophy of the judges, I don't really want to comment on the politics as much as I can discern them of individual members of the judiciary. But it's possible to look at some of the recent cases on voting rights, on perhaps on climate change, and on sentencing, and identify that several of them could be seen as cause célèbres of the political left. And that's the danger for the courts. They don't want to we desperately don't want them, and they don't want to be politicizing themselves in a way that exposes them to criticism. That would be a disaster both for our judiciary and for our legal system.
Okay, let's take the next question, and that one is probably one for Jack. Are we heading towards a common law constitution by stealth?
There are lots of difficult phrases in that very short question. Constitutional is one of those words where, to sort of mangle somebody else's quote, I sort of think about reaching for a gun. It's a very dangerous phrase. It's a bit like rights. It's usually used rhetorically rather than particularly accurately. And it's not particularly useful in a country that doesn't have a written founding basic document of a kind like the US Constitution, which we simply don't. So common law constitutionalism has become popular largely through the British approach, where the British thought they were going to be, or some academics and judges thought that Britain would leave the EU and also leave the human rights arrangements there. And so to set up something that would survive that, there's been a focus on common law constitutionalism along with the principle of legality that Roger referred to earlier. And yes, there is a risk that we are moving down that track as the courts are saying, we don't have a written constitution of a formal kind. The constitution is what the courts say it is because they declare the law, and therefore we will start to, by a process of accretion, start to create a constitution created by the judges. Now, that's a particularly problematic exercise to undertake in a country which consciously doesn't have a constitutional document and which has ignored all opportunities so far to have one, most recently in relation to the Bill of Rights Act discussion in the early 1990s, and likewise when the Constitution Act was enacted.
Yeah.
Okay.
Can I
Yeah,
contribute a few thoughts on that? I think it would be unquestionably a revolution for the courts to assert that the common law was in some way superior to Parliament, which is what I understand common law constitutionalism to mean. The issue of that was directly addressed by Michael Cullen when he was Attorney General, when the Supreme Court Act 2003 was introduced. The Act explicitly refers to a continuing commitment to parliamentary sovereignty. It was Parliament that created the Supreme Court. It was a Parliament that introduced the English common law to New Zealand, and it was reaffirmed in the Imperial Laws Act just about 40 years ago. So unquestionably, Parliament sits above the courts. And if the courts were to suggest that somehow the common law, the judge-made law, was superior to Parliament, that would be a revolution.
Okay. Let's take the next two questions together, because I think we already answered the first one. Is the real problem not judicial overreach, but parliamentary underreach? We talked about that. But the second question here, I think, offers another perspective. Could judicial overreach be a necessary counterbalance to the tyranny of short-term electoral cycles? In other words, where Parliament is really short-sighted because of the 3-year term, actually the judiciary could take it and look a little bit further beyond.
Yeah. Well, I think the 3-year parliamentary cycle actually has the opposite effect. It means that our parliamentarians passing laws are accountable to voters every 3 years. So it's a strengthened form of accountability. So it lessens the need for an activist judiciary, because whatever Parliament does gets taken back to the voters every 3 years. So I think our 3-year term, I think our 3-year term's too short, but whether it's a 3-year term or a 4-year term, it ensures political accountability for political decisions.
Jack, do you have a view on that?
I think the question is encapsulated in the phrase tyranny of the majority, which is the concern that has often driven arguments in various countries, including here, about not having some constitutional document which overrides legislation. For myself, I think the answer is, as Roger suggests, in that form of democratic accountability we have as a form of a general election. To put it in relatively basic terms, you can throw the bastards out. And for that very reason, I'm probably, unlike Roger, in favour of the 3-year terms for that reason alone, because that is the key matter of democratic accountability, and it discourages governments from thinking that people will forget if they manage to overreach themselves.
Okay. Next couple of questions are about the treaty. First question is, do you have a view about whether it would be more fruitful to define the treaty principles in legislation, or remove references to the principles altogether in the context of the Supreme Court discussion? Roger.
Right, I was going to throw that to Jack, given that he addresses the treaty in his paper. I think actually, I'll get you to repeat the question. So should Parliament define the treaty principles?
Should Parliament define the treaty principles, or should it be left to the judiciary, basically? That was the question.
Well, I don't think Parliament should have enacted a reference to treaty principles without defining them. Whether it should have enacted a reference to treaty principles is another matter. And a little bit like Jack's view on the Bill of Rights, I think it would have been best not to. Where we are now, well, we're in a bit of a muddle.
Actually, I might just take the next question straight away and then pass it on to Jack for further comments, because Alistair is asking, talk about the treaty in this debate. Is it a historic reality? Is it a de facto constitution? Is it a tribunal authority? And where should we be going? That's quite a lot of questions in just a few words, but over to you, Jack.
That should be able to be answered in about a year.
Exactly.
Of solid thinking and speaking. The treaty is obviously a difficult issue, but that, I think, is the key point in relation to the judicial role. Where judges and courts have the biggest problem is where there is not a consensus in the community. And that's why abortion has been the classic issue that has caused problems in other jurisdictions, and in particular the US. Whereas here we muddled our way through the contraception, sterilisation, abortion legislation through Parliament, and the issue has never been as acute as it was there because it was imposed by a Supreme Court majority. So I think it's probably uncontroversial to say that there isn't consensus on the role of the treaty in our society. As a matter of strict legal history, I understand it not to be the founding document of New Zealand. It is, and it's a perfectly good argument to say that, in fact, the regimes we are living in now is based on a series of revolutions that took place during the latter part of the 19th century. But they weren't revolutions by judges, and judges aren't well suited for revolutions. And so I don't see that that's a role for judges to play. Insofar as the treaty is going to continue to be A, important, but B, controversial, that seems to me a good reason why the courts should be kept out of it. And if they won't do it on their own bat, and they shouldn't be encouraged by references to the treaty and legislation, then there may have to be some protective legislation around that. But whether Parliament can do it by way of defining principles, or simply let the process work its way through a dialogue outside the law, which seems to be more sane, then that remains to be seen.
Mm-hmm.
I think it's worth noting that we, on the treaty though, that we did have more or less cross-party consensus on the treaty settlement process for nearly, and that was the focus of the treaty, restoring rights under Article 2, or making good. With finding a 20th or 21st century solution for wrongs that occurred mostly in the 19th century, and so we did have broad consensus. It's broken down over the last 5 or 6, not so many years. So it's not beyond the wit of New Zealanders to regather and get back to some form of consensus.
Okay. Well, let's stay in this area and check the next question. Someone here asks, in Ellis, the court said that tikanga is part of the common law, but also that it was not competent to pronounce on its content. So, Roger, is this a rule of law problem?
It is absolutely a rule of law problem. The Supreme Court has created chaos in the Ellis case. It made several important mistakes. It made a mistake about the legal status of the English common law, which Parliament determined was the law of New Zealand. New Zealand's Parliament determined that. The common law has always, so that's judge-made law, has always recognised general or local custom as law, and aspects of tikanga that fulfilled the common law's requirements to be recognised as law, which include certainty and a long-standing acceptance of the custom. But the common law courts for more than a century had recognised that tikanga could form part of the common law. The Supreme Court threw all that out and didn't replace it with a new rule of recognition for tikanga. So we're left with chaos. And the pronouncements from the majority judges in the Supreme Court case in Ellis are really the antithesis of the rule of law. There's not a scintilla of certainty or predictability amongst them. And so I think this is an area now that is crying out for legislative invention. The court having created chaos, I think Parliament will have to step in.
I say that Ellis is perhaps the most troublesome decision that I have seen from the Supreme Court to date in its implications. And it's regrettable that it wasn't the subject of greater debate and thought and more humility, if I can put it that way. But what we effectively have the majority declaring is that we have a bi-jural system, that the common law, all aspects of the common law may be subject to the values that to be infused from tikanga. And against that, it's rather hard to avoid the impression that the majority saw this as part of a decolonization process about which most of us don't fully understand what is being contemplated by the court. And the striking thing about all of this is that there's no cost-benefit analysis done of what that bi-jural approach means. If we don't know what the common law means in an area because there may or may not be a tikanga component, then we have just ratcheted up by a serious magnitude the level of uncertainty in the courts and the law, which creates its own costs, both human and economic. And as an exercise in judging, it is seriously problematic. The best answer to the majority's decision was given by the minority, who pointed out very eloquently all the things that hadn't been asked and answered in the majority's approach. And the question whether the stable door has now been left open and tikanga has bolted remains to be seen. Before that, there was a case called Takamore involving the question of a deceased body and rights in relation to that, or interest in relation to that. In my view, that had a very balanced approach to where the law should deal with these issues. And I didn't see any reasons in the judgments in Ellis why Takamore shouldn't have been left as it was.
Mm. Next question comes from our colleague Michael Johnston, and he asks, do you agree with me that judicial overreach is a symptom of an underlying decay in cultural esteem for democracy? And if so, can the solutions you propose succeed?
Well, I'll have a crack at that. I think there may, in some quarters, be a disdain for democracy, but I think if you ask the median voter, they still value their vote very highly. So, I think culturally, democracy is still one of our strongest values. I think amongst certain elites, there is a bit of a disdain for the ordinary person making major social policy decisions through the exercise of their vote. I think our democracy is still very healthy.
Okay. Next question also for you, Roger. Do you have any hope that the current government will pick up any of your 5 recommendations?
Well, I have strong hopes that they will pick up all of them. But if not in the next 18 months, then in the next term or the term of Parliament after that. I think probably from a realpolitik perspective, what really will have to happen for some of the recommendations to get traction is the Parliament will have to feel burnt by an overreaching Supreme Court decision on its watch. They might have felt that if they'd still been in government in 2021 with the 3 strikes case. They were certainly very staunch critics of the Supreme Court from the opposition benches. Labour were very staunch critics. The tempered language of the Supreme Court given about its decision in D and the Police, which I refer to and Jack goes into in more detail. But I think I think some of these reforms will be implemented. So yes.
And Jack, how do you read the politics?
I'm sorry, can you repeat that?
How do you read the politics? Do you think it's likely that we will get some of the recommendations implemented?
Yes, I do. Not all, but some. And I think it's more than a straw in the wind is the recent bill to amend the Marine and Coastal Areas Act to overturn the decision of the Court of Appeal in relation to the scope of that legislation is an indication of what the present government is minded to do. That is quite strongly worded legislation telling the Court of Appeal that it got it wrong. And the debate around that will be extremely interesting to watch for those of us who take some interest in these matters as it progresses, because it won't be sort of met quietly by those who favour a different approach or favour the Court of Appeal's approach. But I think it's an example of the government being prepared to do something stronger in telling off the courts than I've seen any legislation before.
Okay. I just want to stay with you, Jack, because someone's obviously taking issue with one of your comments earlier. Do you really not see Treaty of Waitangi as a constitutional document, along with, for instance, Magna Carta, He Whakaputanga?
Well, I'm unapologetic to say it isn't a constitutional document in that sense. It doesn't form the basis for the current legal order in a technical sense, and it doesn't have the same, that system hasn't picked it up in the same way that the Magna Carta has by things like the Imperial Laws Act. So working out precisely what role it has remains to be seen. That doesn't mean it's not important. It just means I don't see it as a founding legal document.
Okay. I think the next question we already discussed, and that was the extension of common law to tikanga. I think we discussed this earlier. The next question I find really intriguing because someone is asking whether the tension that we have between Parliament and the judiciary is a feature of democracy and not a bug. In other words, I mean, this will always be with us, and you can do whatever you like in reforming the Supreme Court. But in the end, there will always be a natural tension between the highest court in the country and Parliament, and that's probably quite a healthy feature of democracy in a way.
I think there needn't be. I think if the machinery of government works best when everybody, this is Parliament, the courts and the executive, stay within their lane and perform their functions appropriately. There's more likely to be a tension between the courts and the executive. And I think that is a feature of our democracy. With the courts reviewing executive decision-making power. But I don't think then there's anything built into our system of government that requires there to be a tension between the courts and Parliament. There's certainly a role for the courts and Parliament to say the law's in a mess in an area, and that can come up in a case. Parliamentarians aren't blessed with the wisdom of Solomon, so our laws inevitably don't foresee every eventuality, and sometimes there are flaws with them. And in that case, it's the court's role to point that out to Parliament. And one of the beauties of our unicameral system is that we can very quickly move to fix flaws in our laws. Parliament can move very quickly to fix flaws in our laws. Yeah, so I think there's an inherent tension between the courts and the executive, but I don't think there is a built-in tension between Parliament and the courts.
There's probably 2 points I'd add to that, Oliver. I agree with it, but and the judicial review by the courts of executive action is an important part of the rule of law. There's no question about that. But the inevitability aspect of the question, the answer to that is, at least I didn't see any signs of this tension at the level we're talking about prior to the current decade. That I think is a short answer. Then the question is, why is it happening now? That's a more complex question, and our papers, respective papers, address that to some degree. What was striking to me as I was researching for my own paper was the fact that this is an international trend, and you have issues that are rising in various places. Some of the more sort of spectacular examples are Israel and Mexico, for example. But what it does seem to suggest is that possibly because of the nature of modern media, possibly because of other trends, there has been some concern about democracy or impatience with democracy, and the idea that the judiciary can and should try and do things now. The environmental concerns are one aspect of that. There's a strong push in environmental litigation to say this is too important to be left to Parliament. You can't wait for Parliament to get it right. The courts need to do something now. And there's that kind of call which is being answered to some degree already around the world, and arguably in the Smith case here. But what that is calling for is a judicialization of issues which previously hadn't thought to be at all judicial issues.
I'd like to ask a quick follow-up on that, if I may, just outside the normal Slido questions. My first job after leaving university was actually in the House of Lords as an advisor, and I could see how the House of Lords as a revision chamber basically worked in fixing up shoddy legislation coming from the Commons. Now, of course, in New Zealand, we have a unicameral system. So in a way, that puts the courts in that position where the House of Lords is in Britain, basically pointing out shoddy legislation, shoddy lawmaking, which happens in New Zealand occasionally. So in that sense, there is a bit of a tension between the courts ideally and Parliament, where the courts actually perform the function of just pointing out where some lawmaking is actually not quite up to scratch.
Well, I think it's appropriate for the courts to point out where the lawmaking is problematic. The beauty of our system is that Parliament can generally quickly fix it up. And that's the proper course, not to turn our courts into an upper house or into a constitutional court. That's not our system of government.
Okay. Next question then. Is there anything at all constraining Parliament's authority to legislate, and hence a role for the courts to serve as a check on that authority? And I suspect the answer is probably a single word from both of you.
Voters.
No.
Voters and no. Okay.
Yep.
Anything else? So there's nothing constraining. Sovereignty is
Probably
absolute.
revolution would be the other one, but that's in addition to voters, but
Yep.
maybe it's a version of voting.
Yeah.
Parliament rules with the implied consent of voters, and if it does something outrageous, then voters will revolt.
Okay. Next one for both of you. Can you recommend any books or case law that give a neutral account on the legal status of the Treaty of Waitangi? Well, that's probably problematic, Jack. Is there anything entirely neutral?
There are vast numbers of books already on the Treaty of Waitangi. Matthew Palmer, now a judge of the Court of Appeal, has a good book on it. Ben Fletch has written a very lengthy book on that. There are any number of good books. We need to read all of them. You can't just read one of them. Well, not all of them. You need to read a range of them. And in recent times, this is what the Academy has been focusing on, and for the most part, by those who have an enthusiasm for revisiting the current status quo. For myself, my preference in terms of reading about the treaty has been the late Professor Brookfield, who had the revolutionary theory about government in New Zealand, which I tend to adhere to myself.
Yeah, likewise.
I believe I can almost answer the next question myself, and that's what's the initiative's engagement with the coalition government on these issues? Well, I can say that we've made this report available to all parties ahead of the release, and we've had discussions with politicians really over the years across the political spectrum. So this is not a party political issue. And as Roger already alluded to, we think that actually there should be sympathies across the political spectrum for the report and for the recommendations we make. But Roger, would you like to comment further?
No, I think you've covered it pretty well, and I agree. It's not a party political issue, and the most senior politician I quote from in the report is Michael Cullen.
Okay. Provocative question for you, Jack. Could excessive judicial restraint be as dangerous as judicial activism?
Haven't seen much evidence of excessive judicial restraint that I can really comment on. I don't want to sort of hark back to the idea that we've just emerged from a golden era, but I can see and saw nothing that caused me concern in the decades leading up to the present one, having reasonably close acquaintance with the legal system and including the Supreme Court. And so in those systems, the judges were jealous of their position, not least in relation to judicial review of executive action to maintain the rule of law, the rights of criminals or accused persons in the criminal justice system, and so on and so forth. I think all of that was entirely appropriate and wouldn't go away if the kind of concerns that Roger's paper is focused on were addressed directly. That isn't going to undermine anything else, in my opinion.
Mm.
Yeah, the notion that it's the court's job, it's the job of the current cohort of senior judges to take our law on a journey to live up to their view of society's current values. I mean, that's the most dangerous concept. That's the judges deciding they're politicians, and that's a relatively new phenomenon. And it's one that Parliament must push back on vehemently.
Okay, let's take one more question. And I think this is a question that once again lends itself to a one-word answer. Is the real problem our lack of a single codified constitution?
No.
No.
I thought so.
Go ahead. As an example, you only need to look at the extravagant decision-making by Supreme Courts in countries with written constitutions, whether it's on the political left or the political right. Canada's Supreme Court invented a right to medically assisted euthanasia out of the right, which I'm in favour of, but they created that out of the right to life in the Canadian Constitution. It was the quintessential judicial overreach. So I think a written constitution creates, in a way, even greater risks for judicial overreach or of judicial overreach.
It's inevitable, I view. If you're going to have a constitution that overrides Parliament, somebody has to interpret it. that's going to be your Supreme Court, that makes it a constitutional court and judicializes major social and political issues.
Okay. In which case, we'll just take one final submission from Slido, but that's not a question. Here's someone saying, I just take the opportunity to commend Roger and Jack for their forthright, clear explanation of our predicament. And I think on that note, I just want to thank both of you. I want to thank you, Jack, for your comments on Roger's paper, Roger, of course, for the paper itself, and to both of you for having this debate with us. I think there is much more to talk about, and now we look forward to the political response to this report. But to all of you watching, and there were quite a few of you on this webinar, at times more than 120, please read the report. It's on our website, nzinitiative.org.nz. Who makes the law? That's where you find it. You will also find a column by Roger in the Herald over the next few days on the report. You can also listen to a podcast we recorded with Richard Eakins, who was kind enough to provide the foreword to the report. And Richard is a Kiwi, but now works as a professor of law at Oxford University, and the foreword is well worth reading. But for now, that's all we have time for today, and I look forward to seeing you all again on our next webinar. But thank you very much for the discussion today, and see you next time. Thank you, Jack. Thank you, Roger.